Lord Hamlin will hand down the judgment.
A defence statement is filed by the accused in effectively every criminal case. Its purpose is to set out the nature as well as the factual and legal basis of the accused's defence. The question of law certified for appeal is whether the interpretation of a defence statement is a question of law for the trial judge. This is an appeal from Northern Ireland against the conviction of the appellant, Miss Perry, for collecting or making a record of information likely to be useful to a terrorist, contrary to Section 58(1)(a) of the Terrorism Act 2000. The trial was a non-jury trial, a certificate having been issued under Section 1 of the Justice and Security Northern Ireland Act 2007. The relevant record consisted of coded notes handwritten on cigarette papers, which were found in a perfume box or a bookshelf close to the computer workstation during a police search of the appellant's home. The prosecution case was that the coded notes referred to individuals using ciphers and related to a previous police search operation in 2015, which had resulted in the arrest and prosecution of Kevin Nolan for possession of firearms, ammunition, and explosives. Nolan had been sentenced in 2017. The appellant's defence statement said that the notes were forwarded to her some considerable time after Nolan's conviction and sentence. In the next sentence it stated, quote, "Any currency in the information contained in the notes was considered by the defendant to have long since dissipated," close quote. The appellant's evidence at trial was that although she could not make much sense of the papers, she concluded that they were sent to her as their utility was spent, but could not recall how she had formed that opinion. The judge concluded, among other things, the obvious meaning of her defence statement was that the appellant knew that the notes related to the 2015 arms find and Nolan's conviction in 2017, and this was inconsistent with her oral evidence that the notes made little or no sense to her. This is one of a number of reasons given by the judge for his conclusion that he did not believe the appellant's evidence in relation to the notes. On her appeal against conviction, the appellant contended that the judge's interpretation of the defence statement was erroneous and that this rendered the conviction unsafe. The Court of Appeal considered the issue of interpretation of the defence statement to be one of law. Alternatively, if it was a question of fact, it considered that the judge's assessment of the meaning of the defence statement was justified and indeed was irresistible. In its judgment, the Supreme Court unanimously dismisses the appeal. I give the judgment of the Court with which the other justices agree. Whether the interpretation of a defence statement is an issue of law for the trial judge or a question of fact will depend on the nature of the statement made in the defence statement and the purpose for which it is being relied upon. Where the issue is as to the legal effect of the document, that is a matter for the judge. Where the issue is as to the meaning intended or understood by the parties, it is a matter for the jury. In this appeal, the issue is the meaning of the defence statement as understood or intended by the appellant. That is an issue of fact. The circumstances in which an appellate court may go behind a judge's finding of fact are limited. In the present case, this requires the appellant to show either a misdirection in law or that a plainly wrong or perverse conclusion has been reached on the facts. It is not suggested the judge misdirected himself in law, nor was this interpretation of the defence statement in any way perverse. The natural inference to be drawn from the defence statement is that the relevant sentences are connected. The reason being given for the appellant's conclusion that the currency of the information in the notes had long since dissipated is that it was a considerable time after the Nolan conviction and sentence. No other reason was given in the defence statement or in evidence at trial. No good reason has been shown for going behind the judge's conclusion on the question of fact in issue. The judge's interpretation of the defence statement was confirmed by the Court of Appeal. This is therefore a case in which there are concurrent findings of fact. It is only in very rare cases that it will be appropriate for the Supreme Court to take the exceptional step of disturbing concurrent findings of fact. The Privy Council has a similar settled practice, and the reasons given in the authorities for that practice apply with equal, if not greater force to the Supreme Court, given its prime function of deciding points of law of general public importance.
Thank you. And the court is now adjourned.